Okay. Good evening, everyone. Once again, I think my apologies for also the admission sound which Microsoft Teams makes when people are being admitted into the meeting. It does tend to be a bit annoying, but thank you all for joining us tonight for this discussion on regulations regarding admission to be a legal practitioner in South Africa, particularly in light of the recent challenge in the case of Bruce Chakanyuka versus the Minister of Justice, the legal practitioner. Okay, my apologies. I think I just heard an echo there. So with that, I will start with some ground rules for this meeting. I've been tasked with laying down the law. The meeting is set such that I and the co-host have to unmute or give rights to participants to unmute themselves when they're wanting to speak. This is just to ensure that there's a bit of order throughout the meeting and there's no, like I said, echoing, background music, or just to maintain the decorum of the meeting. You also do need to have your camera enabled, I believe. Okay, I think you can switch on your camera, but the guests, the hosts have the ability to disable your camera, just to ensure that you don't do anything to disrupt the meeting. And then I have spotlighted the videos of all of the speakers so that they remain on this screen and so that the recording also captures our panelists. You please do make use of the chat room function if you'd like to leave any questions throughout the meeting. Tinashe will be, sorry, my apologies. Tinashe will be moderating the discussion later on. So if you would like to ask any questions, he'll see your questions in the chat room and he'll draw attention to those. And at this time, I believe one of our guests was having technical challenges. So if I could ask Sivu to please allow our final guest to unmute themselves, and if you could spotlight their video, I'd really appreciate that. So as I've said, this panel discussion is to discuss the current regulations as they stand regarding the Legal Practice Act. And I should introduce myself at this point. For those who don't know me, my name is Kudzaishe Mukunga, and I'm the current chairperson of the UCT Law Students Council. And this event is in collaboration with the Black Lawyers Association from the University of Nelson Mandela, as well as the Zimbabwe Students Association from the University of Cape Town. And this evening, we are lucky to have 7 panelists to speak to the topic at hand. So I'll just go by and introduce each of the panelists and read out their bios for you all. So the first panelist we have is Dr. Leah Ndimurimo. Dr. Leah Ndimurimo is a senior lecturer in the Faculty of Law at the University of Nelson Mandela, South Africa. She holds a PhD in Public International Law, a master's degree in Labor Law, as well as an LLB. She teaches and has taught in private international law, refugee law, introduction to South African law, introduction to the Constitution and the Bill of Rights, criminal law, public international law, introduction to law and legal skill modules, as well as labor law. She is an author of a book chapter, and has authored and co-authored 11 peer-reviewed articles on human rights, constitutionalism, and labor law in South Africa. She has also presented 23 conference papers at national and international levels. Her research interests are international human rights law, humanitarian law, refugee law, constitutionalism, labor law, transitional justice, and interdisciplinary studies in South Africa. So thank you very much, Dr. Ndimurimo, for joining us for today's discussion. The next panelist I shall introduce is Dr. Nomfundo Ramalekana, my apologies. Nomfundo completed her LLB at the University of Pretoria in 2014. She then worked at Bowman's and moved to the United Kingdom to pursue a Bachelor in Civil Laws in 2016, as well as an MPhil in Law in 2017 at Oxford University. Whilst at Oxford, Nomfundo worked as a graduate teaching assistant for the Comparative Human Rights Law and Comparative Equality Law courses on the Bachelor of Civil Law. She is also a researcher at the Africa Oxford Initiative and a blog editor for the Oxford Human Rights Hub blog. Nomfundo is a lecturer in the Department of Public Law at the University of Cape Town and has earned her PhD in law from Oxford University. Her PhD is on affirmative action in South Africa. So thank you very much, Nomfundo, for joining us for this event. I should also note and thank Nomfundo for her instrumental hand in putting together this event. The event was initially going to be on a different topic, but thankfully she contacted us about this topic and was able to also help us in securing some of the panelists tonight. Our next speaker, who I might have to take a moment to spotlight, as I don't see them on the screen. My apologies, everyone, for the technical aspect. If you just give me a second. Okay. I might have to. Okay, there we go. Our next speaker is, okay, I think it's now showing. Our next speaker is Mr. Kanyiso Nkulunga. And Kanyiso earned a BCom Law LLB and works in social justice activism, and is also a columnist with different news outlets such as News 24, a contributor for Eyewitness News and the Daily Vox. So thank you very much, Kanyiso, for joining us for today's seminar. The next speaker I shall introduce is Professor Pierre de Vos. Pierre de Vos is the Claude Leon Foundation Chair in Constitutional Governance and the head of the Department of Public Law at the University of Cape Town. He is also a co-editor of South African Constitutional Law and Context, and serves on the board of PEN South Africa and the Advisory Council of CASAC. Our next panelist or speaker in this discussion is Ms. Rutendo Muchinguri. Rutendo Muchinguri completed her LLB with distinction and LLM from the University of Witwatersrand in Johannesburg. From 2012, Rutendo would intern at local Harare law firms called Muvingi and Mugadza during vacation breaks, and was retained by the firm, rising through the ranks to become the practice manager, which was a dual role of administrative oversight and legal advisory. In June of 2021, she signed as a senior associate at a commercial law firm in Harare called Beram Samba. Her areas of focus are corporate advisory, energy and mining law advisory, specialized commercial litigation, insurance advisory, commercial transactions advisory, and specialized property transactions. So thank you very much, Rutendo, for joining us for this discussion. Next, we have Mr. Mchengeti Hwacha. Mchengeti Hwacha is the founder and executive director of the Asylum Seeker, Refugee and Migrant Coalition. The coalition is a registered non-profit organization with a membership of non-citizen law students, academics, and legal practitioners. The coalition's primary objective is protecting non-citizens' rights to work in the legal industry through advocacy, litigation, and other intervention. Additionally, the coalition seeks to contribute to the broader public discourse on issues facing the non-citizen community in South Africa. The coalition is the fourth applicant in the matter, and it brought together the other applicants to bring the case. So thank you very much, Mchengeti, for joining us for this discussion. And last but not least, we are joined by Professor Joanna Botha. Joanna Botha is an associate professor and the head of Department of Public Law at the University of Nelson Mandela. She holds degrees BA, LLB from Rhodes University, as well as an LLD from University of Nelson Mandela. Joanna lectures human rights law and the legal interpretation at undergrad level and supervises many LLB, LLM, and LLD candidates at a variety of topics on human rights law. She has presented numerous papers at national and international conferences and has published extensively in fields of freedom of expression, hate speech, and equality. Joanna has been awarded the Faculty Researcher of the Year Award for 4 consecutive years, with her research focusing on deployment of a regulatory framework for hate crimes and hate speech, which appreciates that intergroup hospitality is linked to social hierarchies and power dynamics between marginalized communities and those with in-group status. Joanna represents the Faculty of Law at as an institutional partner of the Law and Development Research Network, an international research network which aims to advance knowledge and understanding of the socio-legal functioning of countries in the global south. Joanna has also represented Africa as a legal expert in the legal expert consultation of the Ad Hoc Committee on Complementary International Standards, ICERD, in October 2020. So thank you to all of our panelists for taking the time out of your evening to discuss this matter. I should also welcome and thank all of our guests for being willing to join this discussion, and recognize the Acting Dean of the University of Nelson Mandela, Dr. Lynn Biggs, as well as the Acting Deputy Dean, Advocate Lindy Kotsi, for also joining this discussion and listening in on the topic at hand. So I have laid out the ground rules, or please remain muted and with your camera off unless you'd like to ask a question. Then I'd ask that you raise your hand, and then I can enable your microphone. And please also make use of the chat room function. But we would also ask that everyone remains respectful to the panelists and to the other participants in this meeting with their questions and with their remarks. So with that, which has been a bit of a mouthful, I'm sure we'd like to all jump into the topic and hear from our speakers. So I'll hand over to Tinashe to begin the discussion and moderate the topic. Thank you so much.
Thank you so much, Kuzi. Good evening to all our panelists. Good evening to all the people who've joined us for this meeting. My name is Tinashe Mseriwa. I am the Black Lawyers Association Academic and Legal Research Officer. I will be moderator for today. Can you please just confirm that you can hear me loud and clear? Thank you. Without further ado, I do not want to bore you with any of the little sense I will bring to this discussion. I would like to invite Mr. Waja to give us some context into this matter. He is the fourth applicant in the matter that's before the Gauteng North Court and Pretoria. Mr. Waja, over to you, sir.
Thank you very much for that introduction. I really appreciate it. Just a quick thumbs up, make sure I'm audible. Okay, great. So I think before I commence, I just want to really commend the students for this initiative. This is something that we've been sort of trying to make noise about for a long time, and have sort of failed to bring it into sort of mainstream attention. So we really want to commend you for your efforts. Thank you. As mentioned, my name is Muchengeti Wacha. I'm the founder and executive director of the Asylum Seeker, Refugee and Migrant Coalition, a nonprofit that basically looks to participate in various initiatives to protect the rights of non-citizens, more especially in the legal industry, but in the broader context of other industries and in South Africa in general. Just for a little bit of background, I'm from Zimbabwe. I studied at UKZN, and I'm currently completing my articles of clerkship at Libya Inc. Attorneys in Johannesburg. So I am similarly affected and very much feel aggrieved, like I'm sure many of the non-citizen students feel about this arbitrary exclusion from practice. So we founded the coalition in 2012. And in 2020, and the main reason was that we felt that it was important for non-citizens themselves to take up the mantle of fighting for their own rights instead of being reliant on the general court of civil society organizations, which for all the good work they do, most of the time can't relate to the lived experiences of non-citizens in this country. And we thought it's important for us to come in and fill that space. In about 2020, we sort of began to look for suitable candidates who can bring this case forward. And we've sort of been building momentum, and it's brought us to where we are now in front of the Pretoria High Court. The CVs of the panelists were quite intimidating, so I don't want to delve too deeply into the merits of the case. I'm going to leave the legal arguments for the rest of the panel. But just for a little bit of background, all three of the applicants, the individual applicants, are individuals who've lived in this country, worked in this country, and have the rights to live and work in this country, conferred upon them by the Department of Home Affairs. Unfortunately, because of Section 24(2)(b), they are unable, despite the fact that they've completed all the other requirements to practice as legal practitioners, they're unable to get admitted and enrolled as legal practitioners. In simple terms, our argument is that the permanent residence requirement in the LPA constitutes an arbitrary limitation of the right to equality. And as you know, when there is any limitation of rights, there must be various considerations that a court or a decision maker must take into account. I'm not going to focus on all of them, and maybe I'm going to hit the 3 points that I think are strongest in this case. The first being that there must be a legitimate government purpose that is served by this limitation. The second being that there must be a rational connection between the limitation and its purpose. And the last being that there must be no other less restrictive means available. Just quickly on the issue of legitimate government purpose, in our research, we couldn't establish, at least in our opinion, a legitimate government purpose for this limitation. As a matter of fact, we found that the purpose actually seems to be rooted in apartheid-era racism and protectionism. And so that's going to be one of our strong contentions, that really this arbitrary limitation came about during the apartheid era as a way to limit Black people from entering into the profession, and now it has been repurposed to limit non-citizens from practice. Back to the issue of legitimate government purpose in sort of contemporary South Africa, the proposition of the state has been that there's some sort of benefit to South Africans by limiting non-permanent residents from practice, as well as some benefit to the public in terms of protecting them from unscrupulous foreign lawyers who may come and take money and then run away. We are of the opinion that both of those defenses don't hold water. We think that, as a matter of fact, the practice of law in South Africa could be greatly enhanced by the inclusion of non-citizens, including sort of attracting more investment. In terms of the administration of justice argument, we really think it would be difficult for the state to establish that it is or that non-citizens are less trustworthy or are more likely to be unscrupulous in their dealings than any citizen or permanent resident. Moving on to the rational connection argument, we don't think that there is a rational connection between the limitation that the state intends to or is imposing and the purpose that it seeks to achieve, and those purposes being, at least in contemporary South Africa, being protecting the labor market and sort of properly administrating justice in the country. We don't think that the limitation on non-citizens in that regard specifically allows the government to achieve the purposes that they purport with this limitation. And then the last one would be the issue of less restrictive means. Where my research in this matter started was out of the Union for Refugee case. I'm just not sure of the citation, but I can share it at a later stage. In that case, the Constitutional Court essentially stated that a permanent residence requirement as a limitation for entrance into an industry can only be constitutionally compliant where it is tempered by some sort of flexibility to allow for varying situations. And we essentially took that same principle from the Constitutional Court, and we're hoping to apply it here to say that where a barrier is so inflexible, it can't stand up to constitutional muster. And so right now in the private security industry, there is still a permanent residence requirement, but a simple exemption procedure allows non-citizens to enter into that industry. And we may be looking at similar relief in this case. I think that sums up these points that I wanted to hit. So just thank you again, and I'm looking forward to the discussion.
Well, thank you, Mr. Wacha, for an introduction and contextualizing the issue beforehand. I hear that you were speaking a lot about governmental legitimate purpose. And I just want to bring in Prof. DeVos and Dr. Ramalikana, if possible. to discuss from an administrative point of view. Do you think that it's feasible? Because I believe law is supposed to be our lived reality. Our reality must reflect the laws that are within the country. With that being said, do you think that it's possible for people who get a Zimbabwe exemption permit, who've got ordinary residence for a year or 3 years, to be admitted as lawyers and be part of the bar? And after those 3 years, what happens thereof? Thank you.
Who's going to start, Nomfundo? Yeah, okay, yeah, you put me in the hot seat. When in preparation, let me start by saying, in preparation for this webinar, I went back to read the Union of Refugee Women case, and I was actually a little bit surprised by the majority decision. And for me, the problem is, then I thought that there's a problem that the Constitutional Court has always had, in that it focuses sometimes very narrowly on a specific purpose, and to say that it justifies a certain act, and that has to be balanced in Section 9.3, the unfair discrimination analysis, by looking at how serious the impact is on the people affected. And what this case, the Union case, showed me was that the court is very bad at conceptualizing the harm, because they focus on the individual. They say there's one person who may not be able to go and practice as a lawyer, but they don't look at the bigger picture, that the very fact that there's such a provision perpetuates the kind of xenophobia that doesn't only affect people who want to practice law, it affects all people who are not South African citizens in some way. In the same way that it did in the Jordan case, that he didn't understand that it affected the kind of assumptions underlying the law that says only the sex worker is criminalized, perpetuates all kind of stereotypes about women more broadly. The same with the Hugo case, where the court, I think, didn't understand that if you're going to make assumptions about who is the primary caregiver of children, that it's always women, you perpetuate the same stereotype. So the point that I think is important is to take this case forward, is to try and hammer that thing, that this harm is very specific, and the harm is made worse by the possible purpose for the limitation. Because the assumption of the purpose, that the purpose being that you want to make sure that legal practitioners are honest and trustworthy, is a flagrantly xenophobic, prejudicial kind of purpose. And the court said in Hoffman versus SAA, prejudice can never be a justification for unfair discrimination. So that line, I think, is a very important kind of argument to engage with. So I don't know if I've answered your question, but I've said what I wanted to say. Nomfundo?
Yeah, I don't have a lot to add on that, but I just, as you were speaking, and I was interacting with students earlier today, and one of the things that we were talking about is Achille Mbembe's conception of like necropolitics, this idea of those who are not really seen as fully human by the state. And as I was listening to Pierre's, this idea of what are the silences in law that allow legal practitioners, lawmakers, to not perceive specific forms of harm, right? To not see them as real harms, because there's a sense of there are those who are outside of the margins of whom the state wishes to protect, who the state wishes to sort of cover in law, and really sort of embody the idea of